Good afternoon. My name is Chuck Common. I'm chair of the American Constitution Society Oregon Lawyers Chapter. Welcome and thank you so much for coming. This is an exciting program that we have. I had the pleasure of attending Professor Morrison's presentation at the law school last night and the Higgins lecture, and it was really very thought-provoking and interesting. I never actually knew what a Brandeis brief or what the Brandeis brief was, but found out soon that it had an important Oregon connection, which I wasn't aware of. But in any event, I think we'll be talking about more contemporary things today with a mix of politics and history and all those good things. But I do want to say that the American Constitution Society for Law and Policy promotes the vitality of the U.S. Constitution and the fundamental values it expresses: individual rights and liberties, genuine equality, access to justice, democracy, and the rule of law. It is a 501c3 membership organization. If you're not a member of ACS, there are membership forms at the table out there. It's inexpensive and a wonderful organization that brings you both the great speaker and a great lunch today and a great setting. We are run by a board, and we're fortunate enough to have many of our board members here today. I'm going to recognize them, thank them for their service, and maybe they could raise their hand as I call their name. They're the people that if you have a suggestion for a program or activities, you should contact. So Jay Austin and Gil Carrasco, Nathan Christensen, and while I'm recognizing Nathan, I should thank him and Perkins Cooley for their hospitality today. I'm not sure whether he's responsible for the weather. Certainly this wonderful setting. There is, I think, one seat at the table left up front if someone would like to sit here. And we may be able to, if we run out of chairs, we may be able to get a few more. Caroline? Did Caroline make it? I guess not. Caroline Davidson is signed up, but is not here. Bill Funk, Charlie Hinkle, Cody Hosley, and Chin Ming. Jim Olesky, a new board member from Lewis and Clark Law School. Caitlin Randall, and John School. Great. Did I miss anyone? Good. Well, these are the people that run the organization, plan the programs, and set the policy for ACS. So if you have anything good things to say about ACS, tell them to me. If you have any bad things to say, saw their hands. Okay. I want to remind you again that if you want CLE credit for this presentation, you have to check off your name on the sign-up sheet on the table. If you pre-registered, if you didn't pre-register, then sign in on the sign-up sheet. Our next two programs are coming up in early November, on November 7th. On November 7th is our annual social. It'll be at the Lindsay Hart Law Office. It's a wonderful event and featuring Supreme Court Justice Jack Landau. It's a great event, no CLE credit, but the food is always great, and it's really a social occasion. And then on November 6th in Salem, we're going to have a re-showing of the film that we showed in Portland over the summer, Mississippi Innocent. So any of you are interested in that, and make it down in Salem, notice to be going out in a few days. wanted to report, sadly, that within the last really 30 days, ACS has lost 3 very strong friends, and I wanted to acknowledge that loss of Barbara Fredericks, who was a wonderful member and frequent attendee in our programs. Monica Smith, a labor lawyer, and former partner of mine, and Judge Carl Haas, who also attended the program. And these losses obviously are felt by all of us. And finally, and most importantly, our speaker today, many of you know Professor Morrison from his work with Public Citizen. He is the Lerner Family Associate Dean for Public Interest and Public Service at George Washington Law School. For most of his career, Professor Morrison worked for the Public Citizen Litigation Group, which he co-founded with Ralph Nader in 1972 and directed for over 25 years. His work involved law reform litigation in various areas, including open government, opening up the legal profession, suing agencies that fail to comply with the law, enforcing principles of separation of powers, protecting the rights of consumers, and protecting unrepresented class members in class action settlements, but covers the gamut of at least what ACS feels are the important protections offered by the Constitution. He's argued 20 cases in the U.S. Supreme Court, including victories in Bull Farm versus Virginia State Bar, holding lawyers subject to the antitrust laws for using minimum fee schedules, Virginia State Board of Pharmacy versus Virginia Citizens Consumer Council, making commercial speech subject to the First Amendment, and INS versus Shadow, striking down over 200 federal laws containing the legislative veto as a violation of separation of powers. He currently teaches civil procedure and election law, and previously taught at Harvard, NYU, Stanford, Hawaii, and American University Law School. He's a graduate of Yale University and Harvard Law School, and served as a commissioned officer in the U.S. Navy, and was assistant U.S. attorney in New York. An amazingly complete resume. We're terrifically privileged to have Professor Morrison here to speak to us.
Thank you all for coming out on this beautiful day. But we've had so many of them since I've been here about 10 days ago. So I guess when I was in Stanford, people said to me, "How did you ever get any work done in Stanford? It's so beautiful." I said, "That's how you get work done, because it was beautiful every day." In Washington, if it had a day like this, people would be taking off from work and going out and doing something. That is for those of us who finally got back to work. As you may know, that a number of people were out of work for a while, which was maybe not such a bad thing for them to happen. Anyway, thank you all for coming. I appreciate the opportunity. So I want to talk about judicial activism today and ask what we should think about. What is judicial activism? So I suppose if you ask the 9 Supreme Court justices and the 180 Federal Circuit Court judges, are they judicial activists? Every one of them would say, "Oh, no, not me. I'm not a judicial activist. Must be somebody else." They're universal denial, and yet the charge is frequently leveled at all kinds of judges and others as judicial activists. There are many ways to look at the question of judicial activism. I want to focus today on the question of how it applies to constitutional challenges to laws that have been duly enacted by legislatures or state constitutional amendments or federal constitution, not federal constitution, state constitution. And in effect, we have the judiciary overruling the considered judgments of elected officials. Marbury versus Madison made clear that the Article III judges have the power and in many cases the obligation to do that. But the question is, when is it appropriate and when is it not appropriate? Obviously, can't be decided when you like the result. Somebody's a judicial activist if you disagree with their result, and not if you agree. And it surely can't be when the answer to the question is clear, because we all know that clarity is in the eye of the beholder, and when people say something is clear, that means that they've reached a conclusion, because it doesn't tell us why. Today, we all agree that Brown versus Board of Education was properly and necessarily decided. No one would accuse anyone who said Brown was properly decided of being a judicial activist. And the question is why? Are there principles and guidelines that at least we can try to see whether that makes sense or not? Unfortunately, there are no clear yes or no answers. There are differences in degree. And my paper talks about three areas that I'm going to talk about today. And I deliberately leave out the First Amendment area with the exception of a little digression into Citizens United, because there's so much to be said about the First Amendment. I think somebody would have to write a whole separate paper about that. So what I want to talk about here are three areas in which judicial activism charges are often leveled, and to think about. One is the issue of the unrepresented individuals who Caroline products, discrete and insular minorities, or not so discrete and not so insular. Second, issues of federalism, and third, issues of separation of power. I should make clear that I was involved in many of these cases in one way or another, so you can assume that I have some bias about almost everything that I'm going to talk about today. I can only talk about a few cases in the paper that are illustrative. The paper goes through some historical analysis, that is by generation of Supreme Courts, and then has a theory at the end. I'm going to work my way through the theory as I talk about each area. And then I'm going to talk a little bit about the Heller gun case, Second Amendment gun case, as to see how that plays out, and then finally to talk about three cases that have been decided in the last 2 years by the court: the Affordable Care Act case, the Shelby County voting rights case, and the Defense of Marriage United States against Windsor. And you'll see whether my theory holds, which of course is ultimately for you to decide. So, protecting the rights of the unprotected, essentially. Why is Brown universally accepted as being proper and not judicial activism today, when it's clear that at the time the 14th Amendment was written, schools were segregated and were segregated and continued to be segregated for many years thereafterwards? It seems to me that if you have any theory of courts stepping in, that this was a minority, racial minority, that not only had relatively few people in it, but they were in situations in which they had, in addition to everything else, had no right to vote, and there was no possibility of being changed. And if you think that the Constitution is there to do anything, and courts are there to do anything, this seemed to me to be the ideal place to do it, for there was no other avenue. Similarly, cases like Baker against Carr, in which the issue was political gerrymandering, the same kind of problem existed there. That is, those who were objecting had no way of changing because the people in power were going to continue to keep the system the same way it was before so they could remain in power. And if the federal courts had not been willing to step in that case, we would have continued to have the kind of gerrymandering that was there then as well. So similarly, I see the same true with regard to protecting the rights of those accused of crimes, and whether the Bill of Rights in particular should be extended to defendants in state court actions. There are really three subsidiary questions in this. Number one, should the Bill of Rights be applied to the states? It is, after all, only applied to the federal government under the Constitution. Second, should those rights be read broadly or narrowly? And third, what should be done about remedies, in particular the exclusionary rule? And as we all know, the court said yes, 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 and extended the rights. And the question is it appropriate or not to have done so? Were they stretching the Constitution? Well, perhaps, but in my view, not very far. This was again a situation in which if the court didn't change, there was nobody else who was going to change. No legislator ever ran for office on the grounds that I want to free more criminal defendants, and neither did any district attorney. They all ran for office on exactly the opposite premise. And in theory, of course, the legislature represents everybody, but obviously do not represent persons accused of crimes, in part because they don't have any of their own lobbyists, and they also don't know that they're going to be accused of crimes. Many of them are young and have no right to vote. It's not an identifiable minority the way African Americans were, but it's the functional equivalent in terms of political power and interest. And so rulings in the area of the death penalty, juveniles, and so forth, all seem to be appropriate areas for the court to step in and protect those who are functionally, if not legally, unable to protect themselves. I must say I have more difficulty with some of the social cases, the bans on contraception, abortions, and sodomy. After all of the Supreme Court has struck down laws in all of those areas in situations in which at least some legislatures at various times had done some things to fix up some of the problems. The powerlessness was not so clear and obvious. On the other hand, it was perfectly apparent, indeed, that many of these laws would never be fixed, at least in some of the jurisdictions, absent the Supreme Court stepping in. In many of the cases, the problem was that these laws were extreme, and it's very hard to identify a middle position. But on balance, I think probably correctly the court stepped in, although I don't claim to have impressions on this question, and people could reasonably disagree about whether it should have stepped in and whether it was inappropriately activist to do so. On the other hand, in these cases, I think the overlying rationale for stepping in is that somehow our system of democracy has broken down. That what we expect to have out of the legislature is reasoned discussion and fair outcomes. And groups are not being represented there and don't have voices. And in the absence of the court stepping in, the democracy that we expect to work will not work, hence the need for judicial review. Now, there is a counterexample, and that is the Citizens United case. If there was ever a case where it was hard to see the democracy had broken down, it's the Citizens United case. After all, this was a case in which the court reached out to strike down a law to benefit for-profit corporations when there weren't even any for-profit corporations in the Citizens United case, where no for-profit corporation had ever gone to the federal government and said, please change the rules. We really want to be able to participate in federal elections. We want to be able to make independent expenditures. Nor was this a case in which every jurisdiction took the opposite position. Something like half the states allowed both political contributions and independent expenditures by corporations. And surely nobody could say that corporate America was without power in the halls of the legislature to get change if they wanted to get change. And yet, the Supreme Court stepped right in without any sense that this was necessary or urgent or couldn't have been fixed by other processes. It seems to be an inappropriate example of judicial activism, quite apart from the question of whether it was right on the merits of its First Amendment. So that's category one, the unrepresented. Second, I want to talk about federalism. And the issue here is whether Congress is going too far, whether the court should be stepping in to strike down laws that Congress has enacted, mainly under the Commerce Clause. As you all know, early on when Congress started passing laws, flexing its Commerce Clause muscle, the court had no difficulty striking those laws down, but eventually it changed its mind, and in part, I think, as a recognition that there were national problems that only Congress could solve, and part for other, probably political reasons as well. The court started to allow Congress a much wider swath in using the Commerce Clause, as well as under the Tax and Spending Clause as well. So this raised the question, are there any limits to what the court would allow Congress to do? And the court has said, yes, there are limits. And I suppose that if you believe, as I do, that there is something left in federalism, and that the Congress of the United States can't do anything it wants to do, there have to be some limits. And the question is, who should decide on those limits? Should it be just Congress, or is it appropriate for the court to step in? I don't want to answer the question as to what those limits are, but the question of why the court should intervene. Is there some other kind of structural breakdown that makes it appropriate for the school, or Morrison, not me, another Morrison, in which the Violence Against Women Act was struck down as being beyond the power under the Commerce Clause. There are several features of those laws that, to me, raise questions and indeed danger signals. First is that those laws surely did not involve commerce in the ordinary sense of the word. Nobody was prohibiting guns from being sold or doing. This was a gun possession of a schoolyard. That the connection which the dissenters tried to make between the law at issue and the Commerce Clause was, I think, attenuated at best. You still only have to follow one inference upon another inference as well. Was this a national problem that could only be solved by Congress? Absolutely not. In Lopez, it was clearly a violation of law, even of Texas, to have a gun by the school. And no state, including Virginia, where the Morrison case arose, was the violence at issue there proper. What had happened was that incidents arose, members of Congress do what they do from time to time, which is, we're going to solve this problem. We're not going to not do anything. We're going to do something to deal with this problem. And so they passed the law. Not because anybody needed it. Did anybody object? No, the states didn't object at all. In fact, in Morrison, almost all the states supported the Federal Violence Against Women Act. Texas was perfectly happy to have this law enforced against people who brought guns to school. It meant Texas didn't have to prosecute it. It meant Texas didn't have to keep them in Texas prisons and do anything else with them. So everybody was more than happy to have the federal government step in. And because they were willing to have somebody step in as a matter of policy, didn't oppose these laws, the result was when they came to be passed, nobody raised any federalism questions at all. Very hard to raise federalism questions in the abstract. Surely there were no gun toters or potential rapists who had their lobbies out in Congress. And so the issue was unresolved. It was never faced by the Congress at all. And so it seemed to me that if there are no ultimate limit, if there are ultimate limits, that it was appropriate to step in here where there was no national problem, where the breakdown of the system of federalism seems to have occurred because nobody cared about the principles of federalism when those laws were made. So that's category 2. Third, separation of powers, and here there's a different kind of necessity for judicial intervention. The typical separation of powers case I'm thinking about is when Congress passes a law, generally a broad law having to do with, in the case of Chadha, immigration, or federal election laws, or Federal Trade Commission laws, and they added legislative vetoes on top of it, or in some cases, they provided for congressional appointment of members of the Federal Election Commission, as was, or other kinds of similar things in which essentially Congress was aggrandizing its power. Now, in theory, the president could have stepped in any one of these cases and said, no, I'm not going to let you do this. You're unbalancing the separation of powers, and I, as the president, could stand up to it. The difficulty was that in most of these situations, the alleged aggrandizement was of a quite modest portion of the bill. In Chadha, there was a huge, big problem about immigration and private bills, and Congress had been working on it for years, and the legislative veto at issue there was a tiny portion of a very large bill, and no president is going to veto a bill like that because of that. In addition, in many of these cases, the president wanted the power to be able to sell arms to other countries to reorganize the government, and the legislative veto was part of the trade-off to do this. And, of course, Congress loved the legislative veto. It gave members a lot of power that they didn't otherwise have. They passed broad laws and then checked when the rules were issued or decisions were made. So this was a kind of a long-term structural problem that the president could not, or at least would not in most cases, fight. And if he fought it on one bill, it would come back in on another bill later on. And so unless the court was going to be prepared to step in, no one would be willing to do this. Now, in the separation of powers area, there's what might seem to be a counterexample, and that's instead of legislative veto, I'm talking about the line item veto. As you may remember, in 1996, when Bill Clinton was the president, Congress passed the line item veto act, giving the president what every president has wanted for generations, the power to selectively delete from appropriations bills and some limited tax bills provisions that they didn't like. They found unacceptable for policy reasons. Congress did this in, I think most people think, as a moment of weakness because they thought that if they didn't do this, there was no way they could get hold of the president of spending. And so they gave up this power to the president over the objection of a number of individual members of both the House and the Senate, who said this was wrong as a matter of principle and it was unconstitutional. So the court was asked to step into this. This was not a situation of aggrandizement. Indeed, it's the opposite of aggrandizement. The Congress was giving up the power and giving the president more power than they had. So why was it appropriate, or maybe it wasn't appropriate, but for the court to step in? And I think the answer is that, among other things, the court is the long-term protector of our basic system of checks and balances, and that it tries not to worry about temporary weaknesses in the system, temporary needs of one part of the government over the other, and that its job is to see that checks and balances are there not because this is a war between the president and the Congress, and one side is going to get the advantage over the other. It's because systems of checks and balances are there, in my view, and I think the court's view, to protect us as citizens, to prevent unwise laws from being made, and to see that the powers stay roughly in balance for the long term as well as just for the short term. Some say this was a political question, should have been left to the political branches. I think not. I think that the temporary weakness was something that the court appropriately stepped in to do, and to say, no, this is not the right way to do it, and that we need this for the long-term structural problems of the country. The court could have said, work it out. It's up to you. But my view is it's right and it was appropriate for the court to step in for long-term preservation of our system. Now, let's go take a look at the Heller versus District of Columbia versus Heller, which was called, on the gun case of the Second Amendment. Was the court a judicial activist in this case? And I think the answer to that question, to my thinking, is yes and no, or no and then yes, I think is the way I'll put it that way. District law, which had been in effect for about 20 years at the time this case was filed, made it absolutely clear that handguns were not permitted. Nobody was allowed to have a handgun in their home or in their possession in the District of Columbia, absent a few exceptions for law enforcement. You were allowed to have rifles and shotguns in your home, but you were not allowed to have handguns. And the argument was that the Second Amendment made that law unconstitutional. And there were two related parts of the argument. One is, does the Second Amendment, which speaks about militia, mean that it applies only to create rights in the militia? Or does it also create rights for individuals to have guns on their own, at least in some circumstances? That's the first question. The second question was, assuming that the Second Amendment applies to private individuals, what does it say about the kind of deference that the legislature should be given in terms of the kind of weapons that should and should not be allowed? Nobody was arguing that anybody had a right to have submachine guns in their home. And so the question was where the lines are going to draw. So turning to the first question, it's a little hard to see how the court could have avoided that question. It was stepping into an area. There was an express provision of the Constitution, whatever you thought it meant, that dealt with the issue of the right to bear arms. Second, there was a history behind it. Both the majority and the dissent, and indeed almost all the briefs in the case on this aspect, looked at the original notions and what had happened both before the Second Amendment was enacted and some following what the Second Amendment happened after that. And I don't think the court had any choice. The plaintiff in that case said, I can't have a handgun, I've applied for one, I want one, and you won't give it to me, and it's unconstitutional. Whether you think that's right as a matter of constitutional interpretation or not, hard to accuse the court of being an activist in that situation, confronting the question dead on. If you read the opinion, one of the great ironies of the opinion is there are two dissents, one Justice Stevens on the first part, Justice Breyer on the second part. Both Justice Stevens for the four dissenters and Justice Scalia for the majority look at exactly the same pieces of history. They look at the same text. They look at the same history in England. They look at the same history in the colonial United States and what other states were doing. And both of them say the result is absolutely clear. So I don't know. I mean, it's hard to say how both of them can be right. It's absolutely clear. I've always thought, I participated in the case for a while, that it was unclear. And the one thing we didn't say in our brief was that it was clear. We thought the better view was this, the better view was that. It does show, I think, however, that going back to original meaning doesn't provide any additional clarity, whatever other benefits it may have in constitutional interpretation. So I would say the answer to the judicial activism question on question one is the answer is no. That the court was not being a judicial activist. It had a clear case of controversy in front of them. Somebody had a claim that the court could have and should have decided it, whether rightly or wrongly is not mine for today. Now, the second part of the case is having decided that they're private rights, to what extent should the court have given deference to the judgments of the District of Columbia legislature on whether handguns should or shouldn't be allowed, assuming that there are some limits on it entirely, and recognizing the fact that rifles and shotguns were allowed in your home, and therefore there were means of self-defense available, whether you thought they were adequate or not. In one sense, you could say that the gun owners or would-be gun owners were adequately represented, since everybody had a voice. As a practical matter, most people in the District of Columbia thought handguns were bad ideas. The ban was enacted for three separate reasons. One, keeping guns out of the hands of criminals. Not sure that really worked. Second is domestic violence and how guns were used in the home. And third, suicides. Now, most people don't know this, but there were some studies in there, not perfect studies done. But the suicide rate in the District of Columbia, as a contrast to the suicide rates in Virginia and Maryland, counties which are directly abutted, went way down in the years after the gun ban was enacted. Suicide is really a big problem, and unlike other attempts to take your life, suicide by gun works well over 90% of the time, and something like 10 or 20% for all other kinds of attempted suicide. So that's why the death rate from suicide went way down. So what do we do about it? Well, obviously, most of the people in the District of Columbia, both at the time this was enacted and subsequent, believe that handguns should not have been allowed. Does that mean there's a breakdown in democracy? I don't necessarily think so. It wasn't as though anyone who wanted a gun didn't have the right to vote. They did have the right to have other kinds of weapons in their home. If they felt really seriously about it, they could have moved a couple hundred yards, or in some cases a couple of miles, to one of the suburbs if they felt strongly about it. And some people did do it for that reason. So why should the court feel the need to step in? And the answer is the court simply announced that certain kinds of laws were off the table, including a law that banned all handguns, the most common type of weapon it said there. The court declined to do things that one would have expected in a constitutional opinion, like tell us what the standard of review is. On the other hand, it didn't stop her from opining that there were certain kinds of laws that were okay. Laws forbidding felons from having guns. If it's strict scrutiny, then one wonders whether Martha Stewart and Scooter Libby would have claims against these laws, since they are both convicted felons and would not be allowed to have guns. In any event, I think the court wrongly gave no deference at all to the judgments of the District legislature. Just simply said, if disagreed, these are necessary, and you think they're unnecessary, we think they're necessary, end of discussion. That seems to be an example of judicial activism, that unwarranted refusal to follow the wisdom of the District of Columbia residents in a situation in which the district residents felt very strongly about their guns, and there's no reason to think that at least the views were encouraged, even if they weren't followed. All right. So let me fast forward up to the present and talk about the three recent Supreme Court cases. First, the Affordable Care Act. And there are two parts of the case I want to talk about. One is the Commerce Clause ruling, and second, the Medicaid spending provision. On the Commerce Clause, everybody agrees that there are some limits on what the Commerce Clause can reach. The question is, why shouldn't the court have reached out to say that these limits were inappropriate and unconstitutional? Why was the line drawn at inactivity? As the dissent of Justice Ginsburg points out, the question of whether something is inactivity or not depends on the level of generality in which you ask the question. If the question is focused solely on what somebody does not do today to purchase insurance, that may be inactivity. But if you think about it in a larger sense, that is inactivity never using the medical system, which of course everyone is going to use, then the question is one of timing and how you answer that question, except by deciding what the level of generality is. And the court, of course, used the famous broccoli example to say, well, if we let you do this and I get broccoli, you have to make you buy and perhaps even eat broccoli. To which I thought the answer was, well, it may be unconstitutional, but it's not unconstitutional because of the Commerce Clause and principles of federalism. It's unconstitutional because of the Due Process Clause that applies equally to the state. Was Massachusetts unconstitutional because they, in the words of the court, made you eat broccoli in Massachusetts? Whatever the defect of that law is, doesn't seem to be broccoli is the answer to the constitutional inquiry. On the other hand, whatever one had to say about this, this was surely a national problem. That given everyone's mobility, the fact that people get sick in all sorts of places other than their home state, that the ability of national insurance companies to provide coverage for everybody depended on the fact that we would have close to universal coverage, or otherwise the pool of people who were sick and wanted insurance would be diluted by adverse selection problems. There was no notion here that this was a problem that the states could do on their own or were able to do on their own. Even Massachusetts, there were spillover effects that they needed help from outside jurisdiction. Nor was this a situation in which there was a breakdown in the Congress. Everybody who wanted to be heard was heard. States had more than their opportunity to step in and say, we can do this ourselves, and object to the many aspects about the law itself. This was not a case where there were overriding state policy. All the states believed that everybody should have medical coverage. The question was, who should have to pay for it and how was it going to be done? And here the state policy of freedom of choice, letting everybody decide, was not isolated and protecting only the states. It interfered with the ability of the federal program to do its job. So I agree that there are limits to the Commerce Clause, but I'm unclear as to why these are the appropriate limits and why the congressional process for enacting this law was not sufficient to overcome any concerns that one would have about federalism. In the end, this was, and I think even the majority of the Commerce Clause issue would agree, that this is connected to commerce. The sale of insurance, the provision of medical services interstate. The question is, was it closely connected enough? The majority said no, the dissent said yes. It seems to me that there was unnecessary reaching out to strike down federal laws in this case. The Medicaid spending is another kind of interesting situation. The states objected. On the other hand, under my copy of the Constitution, the states are pretty well represented through the Senate of the United States. No reason to think that they couldn't be heard, weren't heard in that. And yet, this time, by a vote of 7-2, they struck down the 100% penalty for Medicaid spending. I suppose and particularly seeing judge. It may be that it can be explained by two things. One is that the court felt the need to step in and remind the Congress that there are limits to the conditions that can be imposed, particularly on the states, and that the 100% penalty was undue, excessive, and of course, in many senses, it was excessive because it was unnecessary. Doesn't come out in the opinions, but HHS has had a long history of being allowed to withhold Medicaid payments from the states that do not follow the law, but it's never done it. It's been unwilling to step up and do it because of the concern that poor people would suffer as a result. But they surely didn't need 100%. And so maybe this was an example of judicial activism, not because it had a serious impact on the law, but that it was reminding the Congress to pay somewhat more attention to the details of its statute. In a way, Congress can be forgiven a little bit because, as you may remember, there was no conference on this bill. Two quite different bills came out of the House and the Senate. There was no conference because Senator Edward Kennedy had passed away after the bill passed the Senate, and they could not beat the filibuster that would inevitably have occurred back in the Senate. So there was no conference. The House had to pass the Senate bill, and they were able to agree upon a few technical amendments, but many of the things which could have been straightened out and pointed out by staff and outsiders were never had an opportunity to be corrected for that purpose. Second case, the Defense of Marriage Act case. In 1996, Congress passed a law that said that for all 1,100 or more federal laws that use the term marriage or spouse, the term shall apply only to a situation in which the couple is one man and one woman, effectively making same-sex marriages inapplicable for federal law. This is surely a case of a classic case of the unrepresented and being beaten down in the legislation, in Congress, especially in 1996. And if you read the debates, you can fully see what happened, and most of them are reproduced in Justice Kennedy's majority opinion. What do we make of the fact that a law like this almost certainly could not pass today? Don't ask, don't tell was repealed. There would be no way a law like this could be passed today. On the other hand, what do we think of the fact, how much likelihood do we think that there would have been repealed? And what should we do about the fact that thousands of couples, increasing every year, were being adversely affected as a result of this law? If Don't Ask, Don't Tell was repealed, why not DOMA? But what do we do in the meantime? In theory, one's view of judicial activism should not be affected by what you think of the merits of the legal argument. In the real world, it's probably extremely difficult to separate out the victim and the judge what you think the right answer to the question is from whether you ought to intervene in the first place. If you read Justice Kennedy's opinion, there's not a shred of doubt what he thinks of this law. And it would be very hard for him, the harshness of his views about this law, that would ever allow it to stand, or let the notion of judicial activism stand in his way. Here, of course, this was a law that affected 1,100 separate laws. The Congress didn't care about the consequences. They were asked to ask GAO to study the impact of the laws on both in terms of its budget implication and how it might affect other operations. All those things were turned down. Sunset was proposed and rejected immediately. They simply didn't care. And as some of you may know, there are serious perverse consequences from this law. Federal ethics laws don't apply to same-sex couples. All of the laws in the tax code that prevent anti-avoidance provisions, those don't apply. The bankruptcy laws don't apply. Injury creditors and others along the way. None of these things could have happened, would have happened if anybody paid any attention. So maybe the merits did make a difference. And so the court went ahead 5-4, despite there was a serious jurisdictional question as well. The court went ahead and decided the case. But notice it didn't decide the state law companion Perry involving Prop 8. It sent it back because I think it wasn't ready to be that active. It was one thing to strike down a law of Congress that affected most states in only a marginal way, but quite another thing to strike down the law in California, which might have, depending on what theory of regimes, affected all of the laws throughout the United States. The last case I want to talk about is the voting rights case of Shelby County. And this is another federalism question. The court majority said that the voting rights pre-clearance requirement was an insult to the dignity of the states to whom the formula was made applicable. Now, assume that there is a state dignity argument in the Constitution, and that it was proper to apply in this general area. Is this even a threshold proper case? Justice Ginsburg points out in her dissent, this is not an ordinary case of Congress interfering with the states. It was interfering with the states pursuant to an express provision in the 15th Amendment to the Constitution that deals with voting rights and discrimination against minorities and expressly gives Congress the power to make all necessary and proper rules in this very area. So one would think that this is one of the last areas where general principles of federalism and state dignity ought to step in, but it was not. And so the court stepped in that way as well. And in that respect, it's quite different from the Commerce Clause, where there is plainly some limit on what the Congress can do, but by no means so of the Fifth Amendment. If you read the court's opinion, this is a clear case of Congress overriding what the states were doing. But notice, the majority opinion does not purport to say that either the goal, eliminating the discrimination in voting, or that was improper, or that Section 2, which continues to allow lawsuits to be brought, was improper, or that anybody contended that there still are not problems. The court objected to the choice of remedies that Congress had imposed, despite the fact that Congress had very recently examined this very question. It had renewed this, and the votes had been near unanimously in support of renewal, based not on some hearings that were held a long time ago, but on 20,000 pages of record that was accumulated. Justice Scalia rather cynically said in the predecessor argument a couple years before, the fact that Congress is unanimous is itself a danger signal. I don't quite understand how that happens, but that's, I guess, his view about it. They all agreed to do it because they didn't want to mess with anything else. That may or may not be true as a matter of politics, but I'm not sure that I understand why it is the Senate, which is supposed to protect the states, can't protect the states, didn't protect the states here, and why members of Congress didn't do so. So it seems to me to be an inappropriate case of judicial intervention. Now, I wish I could say that if I took all my principles and laid them side by side with every case the court decides, we would come up with a clear, correct answer to judicial activism. That would be nice, but certainly not true. On the other hand, it does seem to me that we ought to try to have some principles on which we decide whether we think courts are acting appropriately when they're striking down laws of Congress. I have no illusions that my principles are clearly right and will answer all of these questions. But I would say, if you don't like mine, then please come up with some other ones. Thank you very much. Questions, comments? Sir?
I wonder if you could give us your take on judicial activism in the context of the tension between democracy in the form of initiatives and referenda and the tyranny and vicissitudes of the majority that seemingly the Equal Protection Clause is meant to address, against the backdrop of cases like, well, Schuett in the present term, but also cases like Wright v. Mulkey, Hunter v. Harrison, and Crawford v. Seattle School District.
Well, so two things. One is, at least to date, the court has never distinguished for equal protection purposes, I think, what was talking about, between initiatives, sponsored initiatives or referendum, whatever it's called in a particular jurisdiction, and ordinary legislation.
And I have not seen any indication that the court is thinking about drawing that kind of a line. They are both legitimate under the laws of the state. Whether are you so as a matter of law, I think that's where the situation stands. Do I think that we ought to be more suspect, which I take is your question, of initiative-based rule? I guess I am suspect of them. Although, given the way legislatures act someday, I'm not sure they're any more or less informed. The things that trouble me most about the initiative process are a couple of things. One is the difficulty in anybody understanding what's going on in these complicated bills. Second, whatever you may think, the Prop 8 in California was a clear question. People may have voted irrationally, according to bias and prejudice, but they understood what they were voting for. I assume that we can deal with the questions about misleading questions in another form. But in many of these situations, there's a complicated provision put there in which the ordinary person can't understand them. I remember I lived in California for 4 or 5 years, and we had to take home the sample ballots and sit there. We would have people over and we would construe the ballot initiatives to figure out what it meant. And most people couldn't possibly do that. The third thing that troubles me is these initiatives, particularly when they amend the Constitution, last forever. And under the laws, at least in California, I don't know what the situation here is in Oregon, it can only be changed by another initiative, which is time-consuming and subject to all sorts of other decisions. So those are non-constitutional and non-equal protection problems, but they bother me very much about the initiative process. But like elected judges, I don't think it's going away anytime soon. Sorry for that.
Yeah, you used the phrase when you were speaking, you said unnecessary reaching out, which I think really aptly describes an attempt to get at the unified theory of judicial activism. And you talk mainly, I think, about necessity. What cases is reaching out required? Is not the reaching out, that is, how far are they reaching out, also part of that? That is kind of look at the merits, I agree, but like when you're talking about penumbral rights, etc., that means you're reaching pretty far. What are you finding? So isn't that part of it, sort of a procedural dimension to judicial activism? How far are you reaching out?
Well, I take it, we'll leave aside the question of whether there's a proper case of controversy in Article 3. The trouble with that is it's very squishy. How far are you reaching out? For example, the Defense of Marriage Act, how far are we reaching out in that sense? We have the Equal Protection Clause. The question is, what does it mean? What does it mean in this context? And even in Heller, it's not reaching out in the sense that there's some penumbra of right. It's a right there. The question is what it means. And second, the question is what kind of deference should we give? So I guess that by your question then, presumably issues like the ban on contraceptives, abortion, sodomy laws, because they are not expressly provided in the Constitution, maybe the court should be more reluctant to do that. But I don't know how to distinguish among those three cases as to whether how far any one of them is in the penumbra as opposed to any of the others. So I guess I think necessity is a breakdown of democracy of some kind or other, is a more useful and more neutral way of thinking about it. But I may be wrong.
Comment on Judge Posner's via culpa on this decision that was affirmed by the Supreme Court. She said this decision was totally wrong.
Well, it was wrong. So is that, just take the voter ID case. Is that a penumbra case? There's no right to vote in the Constitution. There's only the equal protection and the First Amendment right. The First Amendment doesn't speak about voting. What do we do about those kind of rights in the Constitution? So anyway, if you can get back to your question, the ACS bulletin, which I got this morning on my email, the weekly one from the National, has a rejoinder to that by Paul Smith, who argued Crawford, who said, Judge Posner, in all fairness, which he didn't think was very fair, we actually gave you all the facts you needed, you just disregarded them all. And so, whatever you think of that, I do think one thing about that case, and I said it at the time, it was a high-risk strategy to bring that case before there had been an election when you actually could point to people who had been denied the right to vote. I understood why they brought it then, because they wanted to be sure that people could vote in the next election. But it was a risky strategy, and backfired. Well, maybe it didn't backfire. On the other hand, it wasn't just Judge Posner who ruled against the law. Remember who wrote the opinion? Justice Stevens. He wrote the plurality opinion in that case. And when you lose Justice Stevens on a case like this, you got to think maybe something else is going on. And I don't quite know what it is. I think the problem with challenging the voter ID laws is that everybody here in this room has got an ID. And everybody we know has an ID. What's the big deal about having an ID? Why don't you want to have an ID? Because we don't know people who don't have IDs. And that's the way a lot of people think. And so it's a hard sell. As I tried to tell my students, if you were committing voter fraud, is there any dumber way to commit voter fraud than trying to impersonate somebody else at your local precinct? First place is retail fraud. What you want to do is commit wholesale fraud. You only get one extra vote if you do it that way. Second, you are going to a place where A, you may be recognized, and B, the person you are impersonating they may know it's not the person. So it seems to me if you have an evil mind and want to affect elections, this is the last thing you would do. And of course, we know that the big area for voter fraud is in mail ballots, right? The absentee ballots. That's where the fraud is. It's not in this kind of thing. And the reason that Indiana couldn't point to any cases is because there aren't any cases. No sensible book would ever do anything like this. I do think that it's nice that Judge Posner admitted that he was wrong, but it doesn't do any good for the rest of the world, the rest of the country, unless he's going to write an amicus brief in some of the other voter ID cases that are now pending around the country.
We have vote by mail in Oregon, and I don't think there's been any significant evidence of voter fraud. I may be wrong, but I haven't heard of it.
Well, I don't know. There are cases outside of Oregon. Are you all familiar with what Morrison all said about when he died, he wanted to be buried in Chicago so he would remain active in politics?
I get the process-based approach, but one of the things that strikes me is this potentially distinguishing more activist decisions and less activist one is we get into just a lot of probes as opposed to citations to prior precedent. And I think when you look at the Shelby County case and when you look at the Doma case, gas tracks essentially philosophizing about.
Well, I certainly agree with you about Doma. Justice Kennedy uses the word dignity or some variation of it 11 times in about 6 pages. And he accuses them of animus, called it a second-class marriage. The purpose was to denigrate the laws of the United States. I didn't agree with much of what Justice Scalia said in his dissent, but it seemed to me that was not the way I would have written the opinion. Indeed, if you read the briefs, no lawyer in the case ever made those kind of arguments because of afraid what somebody would say from the bench if you would make those kind of arguments. So Justice Kennedy, he had his 5 votes, and nobody was going to say to him, I think you ought to put a little more legal citations in there. And his was largely a due process kind of argument, and yet the case was argued as an equal protection case. If you read Judge Walker's opinion in the district court in the Perry Prop 8 case, it's also combines with due process, but you don't know where both of them, you don't know where due process ends and where equal protection begins. I don't think it's a due process case. Could the state of California abolish marriage, period? Seems to me they could. It's a constitutional right to say that they're married, so it's hard to understand what the due process simpliciter argument is. As far as Shelby County is concerned, there is a bunch of this dignity stuff in there as well. Kenny wrote that too, didn't he? Yeah. Kenny wrote? Yeah, Kenny wrote Shelby County. I think he wrote Shelby County. So,
Roberts.
I'm going to recommend Roberts. But there is a fair amount of it. Conclusory, you can't do this and you can't do that without really pointing to anything and without responding to Justice Ginsburg's argument about the 15th Amendment. It does seem to me to be a pretty strong argument that required more of a response. Yes, sir.
So maybe it kind of goes back to the question this gentleman was asking, which is if you're trying to avoid figuring out how to label something as activist or not without looking at the end result, then maybe you just stop partway through the decision and you ask questions about the actual appellate process, right? The decision about whether to grant cert or not. Is that something that everybody just looks at that and is like, well, why do you want to do that case, right? It's supposed to be reported, supposed to be more, for instance, or something like that. You look at the nature of the evidence that the court's looking at, and so this goes back to your lecture last night about this question of if you're introducing sort of extra record evidence and the court's spending a lot of time looking at that as opposed to focusing on citations to either the existing record or to past case law. Maybe that's a place that you can look, and people might be able to agree on at least maybe a little bit more than if you actually look at the evidence.
Yeah, I don't disagree with what you said. I think I want to try to separate out the merits-based inquiry and how they should get to the merits of the question of whether they should be going there. Surely your focus on certiorari is one. No, the written paper that I have does talk about Bush versus Gore, and I think it's a terrific example of activism. There was no conflict in circuits, there was no prior precedent, but they didn't like the result and they were not going to let it stand. In Citizens United, you may remember that the questions presented on the first argument were quite narrow, and the court decided, even though they could have decided those, and even though in Citizens United, the plaintiff in that case had specifically said it was not challenging the facial validity of the statute for bad independent expenditure. He had a narrow challenge based upon the fact that this particular movie which he had produced was not covered by the law, and there were two or three other alternative grounds they had. The court reached out for it in a case in which there was no record whatsoever on what for-profit companies could do or couldn't do. They made assertions about what shareholders could and couldn't do without any record whatsoever. Whether it would have affected them or not still was clearly procedurally improper, and I can talk about procedural improper. And surely the question of whether to grant cert. In the DOMA case, they had no choice. There were several courts of appeals that struck down a federal statute applied across the board. They really had no choice but to take the case. And even in Heller, there was a conflict in the circuits as to the meaning of the Second Amendment, whether it was militia-based or not. So in that sense, I would accuse them of reaching out for that. And remember, the District of Columbia had filed a cert petition in Heller asking the court to take the case because the district government concluded as a matter of public policy it did not want to be told it couldn't do it by a circuit court, but it wanted the Supreme Court to have to tell them, recognizing that their consequences may be more significant for a Supreme Court loss than it would be for a circuit court.
I wonder if you could comment on the implicit holding in Shelby County that states have equal status among the federal union. As a matter of federalism.
Equal status with the federal government?
No, equal status with each other. I mean, insofar as the coverage of the Voting Rights Act only applied to certain states,
yes.
The court implicitly held that that was a constitutional defect. And I wonder if you could comment on that.
You mean do states have equal protection rights? I'm not even sure they put it in terms of equal protection so much as they put it in terms of dignity. That they were insulted by being told that they were bad boys and girls, and that they had to ask permission from the federal government in order to do things the states have always done. The problem that they had was that, of course, the formula had remained unchanged since 1960s, with very, very minor exceptions since 1965 when it was enacted. And many things have changed. there was, of course, a bailout provision, which they had construed quite liberally a couple of years before, that would have allowed many states to get out. As Justice Ginsburg said at one point, of all the places in the country that have this apply, Shelby County in Alabama was not exactly pure as the dream under the snow. I mean, it had all sorts of violations in it. It could never have gotten out on its own, let alone as part of the state of Alabama, where there are countless cases still being brought. The court didn't seem troubled by that in the slightest. And I don't know, I guess I wouldn't necessarily say that the states don't have an equality argument, at least in some context. But in the context of the 15th Amendment, given the express authorization of Congress to fix these kind of problems, and knowing perfectly well that discrimination of this kind is state-based and differs among the states, it seems to be not a particularly appropriate time for the court to invoke that. But it didn't seem to bother or help it on getting to that result.
Do you think there's any barometer for judicial activism for cases that are brought, perhaps strategically based on the makeup of the court? So if the case is, let's straightforward, if the case is probably wouldn't have been brought if it was 5-4 this way, if it was 5-4 this way, we're really thinking that this court's willing to go where previous courts might not have been willing to go as some sort of barometer, and perhaps that case in that decision might lend itself towards judicial activism.
Well, surely lawyers think that when they're bringing the case. Indeed, many of the people in the gay and lesbian community objected to the Prop 8 case because they said the court wasn't ready for it, and that if it had to decide this case, it would decide it the wrong way. Surely that kind of strategic thinking goes on all the time. But of course, in many of the cases, people are just wrong about what the outcome is likely to be. I'm not quite sure I understand what else you're asking about.
Well, just something, or like Shelby County or something like that. I mean, that law had, voting rights act had been around for decades.
Yes, but it had been renewed, and the objection was that there was no basis for renewal. So many things have changed. Barack Obama was now the president. Look at the number of blacks in various governments along the way, and that it was wrong to rely on the old formula from 40 years ago. And so, at least insofar as the argument is circumstances have changed, you have to take account of current circumstances. I think that's a respectable argument. Whether we reach the same result or not is a different question. But I don't think that's a disreputable argument.
And some of the affirmative action cases where, you have a case and then the basis of the court changes and suddenly now there's a bunch of additional cases chipping away at something that seemed to have been resolved only a few years earlier. That sort of seems like there might be some question to if the case seems to have been resolved and 4 years later is now suddenly being revisited because the court has a different makeup, then perhaps that might.
Well, so let me ask you this question. Does that mean that all these voter ID cases shouldn't be brought now because Crawford was decided the wrong way a few years ago? I hope not. I hope people will think we got a better record and people understand more about what the problems are in the voter ID cases. I wouldn't want to preclude it from being brought for that reason. It's going to be hard to win, but at least has a chance.
On the court reaching out in the Doma case, it seems like Scalia's arguments about the court having basically waded in on certiorari in what was patently a collusive petition goes directly to the sort of thesis that you're laying out. What do you say to his arguments about that?
Well, so let me just be sure we're all on the same page here as remembers what happened. The first of these Doma cases was filed in Massachusetts, a case called Gill. And in the Gill case, the Justice Department came in and defended the constitutional status of Doma, said rational basis applied, and that it was constitutional. On that basis, the district court decided rational basis applied because it didn't have to go any farther, and said it was unconstitutional, utterly irrational. The case then went to the Court of Appeals. The government took an appeal, And about the same time, a number of groups went to see the Attorney General and asked the Attorney General to change his mind and say that it was unconstitutional. I am publicly on record, and I'll go publicly on record again, saying I thought the Attorney General was wrong in refusing to defend Dolan. He was wrong because of two things. The first thing is, this is not a situation in which the power of the executive was being hampered in any way as an exception to the duty to defend all the laws that Congress passes. It's not like China where the president's power was being undermined and the president couldn't defend that law. Nor was this a case in which the outcome was clear. It wasn't as though this law had been struck down and somebody tried to do it all over again. Indeed, the argument that the Justice Department made in these cases was that heightened scrutiny had to apply, intermediate scrutiny had to apply, and that had never been applied to gender preference discrimination before. Never been applied. No court had ever accepted that argument. So my question is, why is the government coming in and doing that? It seems to be singularly inappropriate, but it did it anyway. And of course, it led to things being really screwed up because in order to assure that there was, in fact, adversity on the other side, the House intervened, and by the way, as they had intervened in the Chadha case to defend the constitutionality. The House came in and they did a thorough job. Paul Clement, former Solicitor General, extremely able lawyer, came in and defended the House. As I said to somebody after the oral argument, if I ever get in trouble and done something really bad, I want Paul Clement to represent me. Because he made it seem as though it was just a wonderful hunky-dory law. And there was nothing wrong with it in the slightest. So there was this requisite adversity. The problem was there, the status of the House was not as a party because the House had could not represent the United States. The Solicitor General had continued to remain in the case, and they had filed a notice of appeal, and they filed a certiorari petition to the Supreme Court as a party, even though they agreed. And the question was, did that deal with the case or controversy issue? And the majority said that it did, and it was adequate. Indeed, there were actually 6 votes to hear the case. Justice Alito said, well, he doesn't think that was enough. He thought that the House could come in as a party in these circumstances, and that satisfied Article 3. So you had a vote of 6-3. The opposite occurred in the Prop 8 case, where the governor and the Attorney General did not stay in the case, and they said it wasn't enough. Now, the other thing about the Dolan case that's important is that everybody agreed that Edie Windsor could get her $353,000 plus interest back, having won at the district court where there was adversity. The problem was that this was a nationwide law that was affecting the entire way that the federal government operated. And if you didn't decide its constitutionality soon, the federal government wouldn't know what to do with all these claims, and there were lawsuits going on all over the place. In addition, at one point in the argument, Chief Justice Roberts said to the Solicitor General, well, if you had the courage of your convictions, you would just stop enforcing this law. The trouble is, the Attorney General didn't have that authority because, first place, he can't control what the independent regulatory agencies do. Second, the law applied to the courts. And third, it applied to the legislature. And he cannot tell those other parts of the government what to do. And so, therefore, that was, in my view, a disingenuous or misstated argument. And the problem was, if we tossed this case out, the only way, unless the Attorney General changed his mind about this thing, the only way the case could get to the Supreme Court was if the plaintiff lost in the lower court, lost in the Court of Appeals. Only then could the plaintiff then petition for certiorari. And meanwhile, years could have gone by. All of the cases that had been decided had gone the opposite way, had upheld the plaintiff's position in this case, and it would have been a mess. And I think that very practical reason led them to say, we're going to have to decide it sooner or later. So we're deciding it now. So, yes, maybe it was a little bit of a reach, but I think it was the right reach in that case, regardless of what they did on the merits of the case. It just needed to be decided and resolved, because, as I said, there are 1,100 federal laws affecting everybody in the Union. One of a really nice amicus brief was filed in the case by a group of employers who said, we don't know what to do anymore. We're in a state that recognizes same-sex marriage. We have one set of withholding rules for one group of married people and another for another group of married people. We don't even know sometimes whether they're same-sex or opposite-sex couples. They don't put that down on their employment. They'll have to say whether they're married or not. And we don't know about the benefits. ERISA applies differently in different contexts. So we want you to come in and straighten this out. And I think that kind of plea also made a difference in terms of getting the clearance. Everybody understood that the federal government really needed to have an answer, whatever the answer was, and it needed it sooner rather than later.
Yes. So you began by mentioning that probably no judge would admit to being an activist, and I think there might be one exception, which is at least one exception, Judge Reinhardt.
Yes, okay.
18 years ago at the law school I was attending at the time, he came and gave an unabashed defense of judicial activism and his activism. And I guess my question to you is, some of how he described it, and my memory's a little hazy at this point, reminded me a little bit of your distinction between what was activism and what's not activism, and whether the court really should answer the question and resolve the issue. And I see a potential challenge similar to the argument made that new originalism is really just really constitutionalism repackaged, of how is your non-activism any different than Judge Reinhardt's activism? In terms of you're picking and choosing which cases the court should get involved in, really makes sense for them to get involved in. Judge Reinhardt's deciding when he thinks he should get involved and make sure the right result is reached.
Well, in terms of the cases Judge Reinhardt got involved in, I might agree with him that he might fit my formula. I guess the real question is, would he agree with my viewing on the federalism issues, for example, the Lopez and Morrison? And would he, and where does he come out on that? Does he think that step one in Heller is an act of judicial activism? And so until I see his cases and he sees all of mine, I'm not sure that I would come up with a different answer. I think most people are quite result-oriented. I like the result, and therefore it's not activism. Well, I like that too, but I'm not sure that it answers any questions that we ought to be asking, throwing around majorities. Not in terms of judicial activism, not in terms of the theory.
Well, we're about at the end of the time allotted, but thank you, Professor Morrison. I have to mention our sponsors today. Over here, these are the people that help us sustain the organization, help us pay for the lunches and the other activities that we do. So they're great people. So take a look at that, see who they are. Thank you very much for coming, and we're anxious to get back to this great weather. So thank you all.